operate in a vacuum. Not just today, but every day, the Supreme Court is like any other institution in that the public has an ever-changing opinion of it. And that includes the next Chief Justice. If public opinion polling shows the Chief Magistrate steadily falling in public prestige, then the circumstances surrounding the appointment of the next Chief Justice can either enhance or diminish the standing of the position itself and possibly of the entire court. So when we return, we'll talk to a lawyer for a legal perspective of the issues that have been joined. Welcome back. I'm talking to Attorney Marlon Manuel, coordinator of the Ateneo's Alternative Legal Assistance Center. Is that correct?
Alternative groups.
Alternative law groups. Okay, let me walk through the decision. At its heart, it argues that the ban on appointments does not apply to a very specific case, which is the Supreme Court.
Yes, that's right.
And is this a deviation from established precedent, or is it merely a continuation of past decisions?
It is definitely a deviation. And in fact, the decision was categorical in saying that it is reversing a 1998 Supreme Court en banc decision where the Supreme Court said that the appointments ban applies to the judiciary and to members of the Supreme Court. So it is a reversal of that precedent.
And in turn, that was the decision involving President Ramos's judicial appointments at the end of his term.
That's right. There were two trial judges appointed within the appointments ban period in 1998. And the Supreme Court nullified those appointments.
And based in turn on the decision on Garcia's midnight appointments.
That's right. Based on the Aitona case, where the rationale for the midnight appointments was explained by the Supreme Court to likewise apply to appointments to the judiciary.
So let's put this in the context of the Supreme Court as an institution, both in the past and now. Our law is based on, they interpret a case, they say this is what it actually means, it becomes precedent, and all subsequent cases will refer to that until the Supreme Court changes its mind. Now, in recent years, the Supreme Court has been changing its mind a lot, sometimes on its own decisions.
That's right. In major cases, on major issues, the Supreme Court would, in some cases, reverse itself on a second motion for reconsideration.
Okay. Now, is this in keeping with the past practices of the court? Because in the past, if my impression is correct, you'd have decades, or sometimes the passage of a new constitution is what it would take for an established precedent to be overturned because of new circumstances. Is this happening more commonly now?
Well, theoretically, the Supreme Court can change its mind. But we are hoping to have a more or less consistent ratiocination in decisions concerning similar issues and involving application of similar constitutional or statutory provisions. So we are hoping that the Supreme Court would be consistent in its rulings.
But now it has actually come forward and said, everything that all you lawyers have been studying since the 1960s is different. It's now irrelevant.
That's right. The problem with the decision is not just the reversal of the 1998 ruling, but the reason behind such reversal. And the Supreme Court relied, in the current decision, the Supreme Court relied on the ordering of the provisions in the Constitution. And the court simply said that because we find the prohibition against midnight appointments in the chapter on the executive, then it applies only to executive positions.
Let's refresh the memory of our viewers. There are two things that are in a sense, at bar here. The first is that the Constitution is very clear that it is considered wrong and in fact forbidden for a president to make appointments in the judiciary or the executive branch for a fixed period leading up to an election so that they won't influence.
That's right. That is under Article 7, the chapter on the executive.
On the other hand, there is another provision in the Constitution that says when there is a vacancy in the Supreme Court, it has to be filled within
90 days from the occurrence of the vacancy. And that is what is written under Article 8 of the Constitution on the judiciary.
The specific vacancy here happens on May 17 when the present Chief Justice retires.
That's right.
And therefore the President or those supporting her position argue that because it falls Even if it falls within the ban on general appointments, since the Constitution says it must be filled, then she must fill it. Is that
But
the argument?
even that argument is flawed because the 90-day period will extend beyond June 30. And the half of the 90-day period will happen within the term of the next elected president. And so there is no clear conflict between the two provisions.
But if there's no clear conflict, then how did the Supreme Court merge the two?
That is precisely the problem. The Supreme Court ruled that we have a problematic situation that requires a reading of the two provisions, and a reconciliation was not done. Instead, the Supreme Court said Article 7 should be made applicable to executive positions only. Article 8 should be made applicable to judicial positions, and the President should be given the opportunity, the incumbent President should be given the opportunity to appoint, which again becomes problematic because you have 90 days supposedly even for the incumbent President or the next President to make the appointment.
The counter argument to that is since half of the period does fall within the existing term of the incumbent, and since the Supreme Court told the Judicial and Bar Council you have to have the list ready for the President to choose from on May 17th when the Chief Justice retires. Therefore, why should she dribble it out and not exercise her power within the 45 days she has?
That is correct. And in fact, that is again another inconsistency in the reasoning behind the decision. Because the Supreme Court decision was emphasizing the need to have an immediate replacement. Immediately after the retirement of Chief Justice Puno. But then the Constitution is very clear that there should be a 90-day period that will allow the filling in of the vacancy. And that 90-day period should be a reasonable period when the country may not have a sitting Chief Justice.
Now, my understanding is under the provisions of law, during that period anyway, or whenever the Chief Justice is on vacation or whatever, there is an acting Chief Justice.
And that is the practice of the Supreme Court. Even when the incumbent Chief Justice is on leave, as we have now. We have an acting Chief Justice.
And that is determined strictly by seniority?
Based on practice in the Supreme Court. There is no constitutional provision about that. But what we have to emphasize is that the Chief Justice is a member of the court. And the Supreme Court decides as a collective, whether in division or as en banc with all 15 members in attendance. So the absence of a Chief Justice will certainly not paralyze the entire court.
So it will not have any grave implications about the functioning of government? And
of course not. In terms of the decision-making powers of the Supreme Court, the absence of Chief Justice will not be a liability.
Now, you have weighed in, many commentators, legal luminaries such as Father Bernas have weighed in, all very critical of this decision. But how representative are your opinions of the legal community as a whole? Of course, there are those who support this argument, and they're lawyers too, some of them quite senior. So can we say that there is even a consensus on this case?
Well, if you ask me, I would say that there is an emerging consensus against the Supreme Court decision. Even if some lawyers groups, even if some lawyers, academics have not given their positions publicly before the decision came out, with the decision and with the way it is written, many lawyers are now, and lawyers groups are now willing to speak out against the decision.
But then what are your options? The options would be to appeal to the Supreme Court.
We have the legal options, of course, which is to file the motion for reconsideration. Other interested parties can still intervene and can ask the Supreme Court to reverse itself on a motion for reconsideration.
But that would be difficult considering the overwhelming majority that you had.
That would be very difficult because we only have one dissenting vote in the decision. And to have a reversal, you need to convince majority of the 9 to side with the dissenting vote, which is very unlikely. But we still have to exhaust all available legal remedies, and the filing of a motion for reconsideration will be necessary.
Okay, and then after that, the next point that's reached is the President herself can decide not to exercise the powers she